Assalamualaikum and hello, my name is Muhammad Azhar from Group 10, our team focusing on traffic negligence. The case that I chose is Azrul Ashraf bin Abdul Hadi and Zarif Shafiq bin Zainul Rashid and others that held in Magistrate Court in Taiping, Perak on 2024. This is a civil suit where plaintiff sued the defendant for negligence following a road traffic accident. There are four legal issues arose where the first one is about the first defendant's negligent action, second about the cultivated negligence from the plaintiff, third about the vicarious liability, and last is about the compensation. This is law and application. The first one is traffic rules that state that the plaintiff had the priority, which is right of way at the time of the accident. Second one is the section 5 and 6 of the Government Proceedings Act 1956 that said that all three other defendants were vicariously liable because the first defendant was working within the scope of job at the time. The third law used in this case is the Evidence Act 1950, which applied to admit a document regarding the size of the military jeep. And the last one is the using elements of negligence, which is the first one is the duty of care that said that the first defendant had duty of care towards all other road users. Second one is breach of duty of care, which about the exertion of sudden turn made by the first defendant, and the last element is damages that is satisfied because the plaintiff proved that he suffered injuries because of the accident. The judgment or decision of this case, the main judgment is the court ruled that the plaintiff to be 20% liable while the first defendant was 80% liable for the negligence. Other than that, the court granted compensation in form of money for damages suffered by the plaintiff. Lastly, for recommendation, these are about the clarity of Evidence Act 1950, second one to settle plaintiff claim if they encounter same case like this, and suggestion for the defendant to take note if he wants to appeal after this. That's all for me.
Hi, my name is Ahmad Qais bin Kamar Zaman. I will be talking about a case named Abdul Wahab bin Mat Rashid and Juruterah Jabatan Kerja Raya Daerah Kuala Kangsar and others code MLJU 2096, which have taken its place in the High Court of Taiping, Perak, with a judge named Norwena Mat Nordin. On 4th of December 2019, the plaintiff saw an obstruction on the road on his way to his workplace at RNR Sungai Perak. He then woke up in the hospital after he hit one of the fallen electricity poles, and he then claimed that the defendant was liable for his injuries. One of the main issues that arose is that whether the defendants owed a duty of care towards the plaintiff in maintaining the safety of public roads and whether the defendants have breached that statutory duty of care. The second one was whether the defendants can use Section 7 of Government Proceedings Act 1956 to escape liability. And the third issue is whether the principle of res ipsa loquitur can be used and shifting the burden of proof upon the defendants. One of the comments that I have upon this case is that the Government Proceeding Acts can really be used for these government agencies to protect themselves against these baseless claims from the public. That's all from me. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. The case that I choose that I want to analyze is Ahmad Zulfandi bin Anwar against Muhammad Shahril bin Abdul Rahman. This case was held in Court of Appeal Putrajaya on 16 June 2022. This case was an appeal made by the plaintiff who did not satisfied with the High Court decisions regarding to increasing of his liability. The fact of the case, this accident was happened between the appellant who did not have a driving license riding a motorcycle on the main road to Langkap, and suddenly the respondent who driving a motor car made a sudden U-turn and caused the accident. There are four legal issues that arise in this case. The first one is whether the appellant's lack of a driving license should influence the apportionment of liability in vehicle accident. The second one is whether the violations under Road Transport Act 1987 should influence the assessment of negligence and liability in civil claims for damages in the vehicle accidents. The third one is whether the appellant's injuries justify an award for loss of earning in the absence of concrete proof. And lastly, whether the loss of earning is a claim that must be proven on a balance of probabilities. Moving on to judgment, for liability apportionment, the court reinstated the original apportionment of liability at 30% to the appellant and 70% to the respondent. For quantum of damages, the court awarded 50,000 ringgit to the appellant for loss of earning capacity. My recommendation for this case, the claimants should provide a clear evidence to claim for loss of future earnings. Besides, for the future cases, the courts should ensure that the claimant's breach of law directly contributes to the cause of the accident. In conclusion, this case clarified the separation between the statutory breaches and the civil liability in the motor vehicle accident. I think that's all from me. See you again.
Hello, my name is Muhammad Ikhwan. So the case that I chose for this case analysis is the case of Azhar bin Hassan against Hashim bin Hassan. This case was held in the High Court of Shah Alam on 21st October 2021. Moving on to the facts of the case, this case involving a road accident that occurred on 13 January 2016. This case highlights the key issues of liability and damages. The accident happened between two motorcycles ridden by Hashim bin Hassan, who was the plaintiff, and Azhar bin Hassan as the first defendant. The plaintiff claimed that the first defendant had veered into his lane while riding from the opposite direction. Tragically, Hashim suffered severe injuries, including a traumatic brain injury. Due to his injuries, Hashim was represented in court by his counsel as he was declared medically of unsound mind. In the Selayang Sessions Court, the first defendant was found fully responsible for the accident. The court awarded the plaintiff damages amounting to 1.5 million ringgit. So this is the judgment of the case. During the appeal, the High Court reviewed evidence including conflicting police reports and witness testimonies. It overturned the 100% liability ruling. Instead, it assigned 70% liability to the defendants and 30% to the plaintiff. General damages were upheld, but special damages were reduced to more realistic amounts. Claims like driver costs and physiotherapy were adjusted, while unsupported claims like digital blood pressure machines were rejected. This decision reflects a more balanced approach to liability and compensation. Lastly, here are my comments to this case. Firstly, it is vital to ensure accurate evidence when reporting to authorities because in this case, the first defendant had filed a police report twice due to inaccuracy of original reported details. Secondly, please strengthen your civil case with independent evidence. In this case, there was no independent eyewitness on the accident scene, thus require investigating officer to seek evidence through more detailed testimonies. That's all from me. Bye.
Assalamualaikum and hello everyone. The last case that I selected for the assignment is the case of Muhammad Nur Rizwan bin Misran against Muhammad Amirul Hafiz bin Khairul Azwin 2020. The analysis of the case began with two legal issues that arise from the case itself. Firstly, whether the omission to not having a valid driving or riding license to drive or ride a motor vehicle on the road by the appellant considered as negligence. And secondly, whether a person riding a motorcycle without a valid driving or riding license has the right to be on the road and hence the protection of the law. For the facts of the case, this was an appeal against the Sessions Court decision that appointed the appellant was 80% liable, while the respondent was 20% liable for a road traffic accident involving two motorcycles. The respondent was collided with the appellant who had stopped to make a phone call. As a result of the accident, the appellant was thrown off his motorcycle and was injured. However, the investigating officer found that the appellant was without a valid driving license or road tax or covering insurance when he rode the motorcycle. The court has decided to dismiss the appeal and further reverse the finding of liability against the appellant to 100% on the basis of illegality defense by the appellant and the negligence principles applied in this case. For the recommendation and conclusion of this case, every individual who operates any motor vehicle is mandatory to have a valid driving or riding license because any individual operating a motor vehicle without a valid driving or riding license can be held legally responsible for negligence towards other road users. All in all, breaking the law can jeopardize one's access to legal protection.